Speakers will have 3 minutes for their comments. Madam Recording Secretary, is there anyone who wishes to speak in person?
Chair Vega, we do not have any speakers for this meeting.
Thank you. Moving on, we're to the consent calendar. Item 1 is the regular meeting minutes of April 11th, 2024. The recommended action is to approve the minutes. Would any commissioners like to motion to approve the minutes from that meeting?
I'll approve.
Motioned by Vice Chair Carpenter and second by Commissioner Goronsky. Madam Recording Secretary, can you please do roll call?
Motion to approve the minutes moved by Vice Chair Carpenter, seconded by Commissioner Goronsky.
Commissioner Castillo-Lattin.
Yes.
Commissioner Goronsky.
Yes.
Commissioner Mejia.
Yes.
Commissioner Perea.
Yes.
Commissioner Said. Yes. Vice Chair Carpenter.
Yes.
Chair Vega.
Yes.
Motion approved by unanimous consent.
Great, that ends the consent calendar. Moving on to the study session. The item under study session is training on Assembly Bill 392, presented by Myra Joaquin. I hope I'm saying that correctly. Joaquin.
Good afternoon. Thank you very much, Commissioner Vega. My name is, I'm going to try to be in a place where I'm not giving anyone my back. That didn't work so well. My name is Myra. I can't see okay. Thank you for that. My name is Myra Joaquin, and I'm a staff attorney with the ACLU of Southern California. I work on policing issues, criminal justice, and work on immigrants' rights. Thank you for inviting me to speak with you today. I'm excited to be here and talk more about AB 392 and specifically the changes to police use of force here in California as of 2020. If, there is a time towards the end for Q&A, but if you have any questions about the materials we just covered, please let me know. I'm happy to answer questions, and then again, there'll be more time for Q&A at the end. So today we'll be covering just some general background on police policies and also AB 392 and the reason why AB 392 came to be. And then we'll dive into the changes that resulted from AB 392 and how to apply those changes. And towards the end, time permitting, we may discuss other considerations under AB 392 that I think are just helpful for people to be familiar with because it does impact how investigations occur under the new law and also how charging decisions are made, etc. Thank you. So, purpose of police policies, and I think some of this may sound familiar to many of you in this room, so apologies for repeating some info, but some of the general purposes for police policies in California and more broadly are to ensure that officers follow the law and specifically that there's clear rules articulated for how one can go ahead and follow the law. The purpose of police policies also includes setting higher, more detailed or community-specific standards that guide discretion and improve decision-making to make it easier for an officer to be able to assess the situation and how to respond accordingly in a way that is in compliance with any laws that are in place. And police policies are also intended to increase transparency and help the community understand how it is that a police unit is operating. This is especially important given just a large increase in distrust among the community and the need to ensure that people know how policies are operating, what an officer can do, what their rights are, to help remove that distrust and just create a better relationship between the community and law enforcement agencies. First, I want to discuss what the legal authority was for police force before AB 392, so before 2020. Prior to 2020, there were a few different areas that provided legal authority for the force that was being used by any police officer. On the one hand, there is the constitutional law that says specifies what conduct is violating constitutional rights, and the landmark decision that has applied in unconstitutional law is Graham versus Connor. This is a 1989 case where the Supreme Court held that force must be objectively reasonable. This case came out of a lower court opinion where the court had focused on the officer's conduct at that time and whether in that officer's view their conduct was reasonable. The Supreme Court reversed that decision and said that it's not what the specific officer thought was reasonable, but rather whether their conduct was objectively reasonable. So whether an objective person, third party, would interpret that their actions at the time had been reasonable. That was the standard generally, and continues to be standard in some locations for the police force of use of force law. And it was evaluated from the perspective of the reasonable officer based on the facts that were known to the officer at that time. It also applied the totality of the circumstances, so looking at all the facts, the individual, the officer, the situation, etc. The other avenues that provided legal authority for police force stem from, on the one hand, criminal law, and then on the other, affirmative authorization from the state. And specifically, there's Penal Code 196, which said that under that law was necessarily committed to effect arrest, prevent escape, or overcome resistance. So it provided quite a bit of discretion for officers to be able to use force in instances where they needed to effect arrest or prevent someone from fleeing or overcoming resistance. Separately, there was also Penal Code 835A, which said that to effect arrest, prevent someone from leaving or overcome resistance, all those needed was reasonable cause to believe that the person had committed a public offense. And the force that was to be used was to be reasonable. The standard that was in place then, which again is a standard coming from 1957, and that was consistent with the Supreme Court's decision, was a much more lenient standard because then all it required was for the force to be reasonable and for the officer to have reasonable cause to believe that the person had committed a public offense. It was very broad what this public offense could be, and it also allowed it to be used to effect arrest or overcome any resistance. This was all before 2020. Leading up to 2020, and specifically during the 2019 to 2020 legislative cycle, there was a need in California to address police shootings in counties in California, specifically because of how many people were dying as a result of the use of force. And for example, between 2016 to 2018, the rate at which individuals were dying from use of deadly force in San Francisco has been increasing year over year. And there was a concern among the community, both California and individuals about when officers were using deadly force and the impact that that was having on the number of people that were being killed because of police officers. So AB 392 was intended to address those police shootings, to set a higher standard for when deadly force any force that can result in death could be used, and it created guidelines and laws that better reflect the responsibility that peace officers carry when determining whether to use a firearm. It also recognizes that individuals with physical, mental health, developmental, or intellectual disabilities are significantly more likely to experience greater levels of force during police interactions. On a given day, it's, I think many folks here are aware of that. Can you still hear me okay? Yes.
No, it's horrible.
Hello?
Check microphone.
Sorry.
Hello?
Yeah.
I can try to, this is fine. Thank you. So I think on a given day, there can be up to half or a third of individuals who have physical or mental health or some sort of developmental disability that are more likely to experience a greater level of force if they're interacting with a police officer, simply because that person may have more trouble understanding the commands or what the officer is telling them, and it may be easier to misinterpret their responses or what they're telling you. And so all those circumstances have led to an increase in force being used against those individuals. So AB 392 recognized that and was trying to address that in the way that officers are interacting whenever someone has a mental or developmental disability.
Can I stop you for a second and ask a question?
Sure.
So you said that this was implemented in 2020,
It became effective as of 2020.
and
Sure.
what has been the rates, for example, in San Francisco since this was implemented?
There's been some reports suggesting that as of now, there hasn't been a significant increase in California. However, there are reports in other states suggesting that similar strict laws, like AB 392, have led to a decrease in the use of force. So it's possible that it may be still very early to tell what the outcomes are compared to the data for available for other states.
Thank you.
Next slide. Thank you. And I just want to emphasize this quote because this is one of the first provisions of the law, which says that the authority to use physical force is a serious responsibility that shall be exercised judiciously and with respect for human rights and dignity and for the sanctity of every human life, which I think is something that we can all agree on, and something that's really embedded in the text and the nature of AB 392. I included the text of the of AB 392, specifically the text that we're going to focus on. I won't read it because we're about to cover it in the subsequent slides, but I wanted you to have that so you can always reference it to come back to the actual text of the law. And then we can skip that too. This is mostly so that you have it for your purposes. So what did AB 392 change? It made a new single standard for deadly force that is applicable both civil and criminal procedures, and it changed the standard for when officers can use deadly force from whenever reasonable to only when necessary in defense of human life. So now any deadly force is only to be applied and it's only justified under the law whenever it was necessary in defense of human life. This new standard makes California's threshold for use of deadly force higher than the constitutional standard, and it is meant to avoid any loss of life that's resulting from officers using deadly force, such as firearms, but also anything else that can lead to cause death. AB 392 also provides a strict definition of imminent threat, which we'll be discussing shortly, and it puts specific limits on the use of deadly force against someone who's fleeing and someone who's suicidal. You might recall from the earlier slide that under the previous rules, under previous laws, all that was necessary was for a person to be suspected of having committed a public offense, which can be very vague and can apply to many individuals. Now, there's specific limits for what kind of crime an individual is suspected of having committed before there can be any deadly force. And similarly, because of the recognition that people with certain disabilities experience more force against them than the average person, there's also limits being placed by AB 392 on someone who is suicidal, who might be committing harm to themselves.
Actually, I have a question. So we had a previous presentation, I can't remember what one, but my question is, I had a question for, I'm forgetting his name now. It's been a long week. But on this particular subject about reasonable versus unnecessary, right? And you distinguished that, in fact, this bill exactly made that distinction. And I wanted to get a little bit of clarification because previously we were trained to at least from that person's perspective, that there was not much of a difference, but to me there is. That was the entire point of this. So like for you, if you can talk maybe a little bit about why that's important, and also have other police departments failed to abide by this law and what are the consequences, and maybe some examples.
Sure, happy to. If that's okay, Ms. Cynthia, I do address the necessary and subsequent slides, and so I can come back to some of those.
Excuse me. I'm having a really tough time understanding you. Could you speak a little slower and a little louder, because it's
Yes.
the acoustics are not very well.
Yes.
Thank you.
Another suggestion from past experience. You're swallowing your microphone.
Sorry.
Put it right here like this at your chest, up a little higher. Now just speak normally.
Is
When
it
you
possible
swallow
to
your
give her a different microphone?
Is this better?
I think it could be the microphone, because mine isn't as loud as some of the other ones.
I have a low voice.
Yes.
Because your voice is so low, it's compensated. So you have a deep voice, it's gonna sound.
Is this better?
Yeah.
Yes.
Wait,
Yes.
yeah.
Yes.
No, hold the door.
No.
No, go back to again.
If you have trouble, or if I need to speak slower or louder, let me know. Use that microphone.
It almost sounded clear.
This is clear?
I don't think it's on.
Oh,
It started off strong and then I feel like it turned off.
Testing. No, it's not. Do you think the signal here is?
You can try this one too, right?
Doesn't that fit into here used to? Or is this a microphone? Is this a microphone itself? No, it's into that. No, it's right here, see?
How's this?
That's better.
Okay.
Damn. It's just gonna work on it.
Now you can just stand here like this and speak. No? Like that?
How's this?
Oh, very
Excellent.
Thank you.
Thank you.
And thank you for pointing that out. If I'm speaking too slow, tell me and I'll slow down.
Great.
That's perfect.
Perfect. Thank you. We did move on to the next slide, but that's okay because we're coming back to the key points that I've already started discussing. So the other key changes from AB 392 were, again, with regards to the limits placed on someone who's fleeing and someone who's perceived to be suicidal. So for someone who's fleeing, now deadly force is only justified under AB 392 when the individual has committed or is alleged to have committed a felony. So it can't be any public offense. It can't be, for example, like petty theft if it's a misdemeanor or any other charges that are low-level offenses. It has to be something, the persecution has to be for someone being suspected of a felony where the felony caused or risked death, and not only did that felony cause or risk death, but that the individual would pose a risk of death or serious bodily injury if they're not apprehended immediately. So there's multiple requirements that need to be met before an individual who is fleeing can lead to an officer justifiably using deadly force against them. And this is in large part because of the number of individuals who have been shot to death when they're fleeing, and it's attempting to minimize those circumstances from happening, especially if the individual is not posing any risk to the officer or to anyone else. Additionally, there's limits now for suicidal people, right? And so if an officer is conducting a wellness check, for instance, or is in close proximity to someone who it looks like they may be committing harm to themselves, that itself is not enough for an officer to be justified in using deadly force. It has to be imminent risk of death or serious bodily injury to someone else. So it could be to the officer or to a third party that's there, but there's no justification for the threat to themselves. And that's merely to prevent an officer being the reason that someone ends up dying from deadly force, and even if it seems that they're the ones who might be imposing a threat to themselves. Something else that's important from AB 392 is that it requires the use of alternatives. Officers have ample training, right, in how to deal with de-escalation tactics or assess circumstances, respond to situations. And so AB 392 recognizes that and asks for officers to use other available resources and techniques if reasonably safe and feasible. And that last part is important because it also recognizes the need for officer safety, right? And to ensure that any alternatives that they're using won't necessarily expose them to risk, to any imminent risk, but rather those available resources and techniques are to be used if they can be used reasonably, safe, and if they're feasible.
Is that last part an objective standard or a subjective standard?
All of this is within an objective standard, within the context of an objective standard and totality of the circumstances analysis. Sorry, someone else had?
Yes, that's it. And sorry to put you on the spot on this, but I think it helps to visualize like examples. Are you aware of a case, preferably in Southern California, but if not, somewhere in California, where if looked through the lens of AB 392 now, it will be considered wrong?
Yes. So as I mentioned, I work with the city of Southern California. Most of my work actually focuses on Kern County. And in Kern County, there have been examples where, for instance, there was an individual who he had mental illnesses, and one evening he left his house to it's unclear what was the reason that he left his house, but he went to walk around, ended up in the hospital because of his status and because he fell asleep at the hospital lobby. The staff at the hospital asked him to leave. He left the hospital, went to the sidewalk and started laying down and just fell asleep in the sidewalk. Someone who observed him falling asleep and just laying down on the sidewalk, they contacted the police. The police in Kern showed up, and rather than using any other alternatives or doing some of the other things that are required by AB 392, which we'll speak to later, as identifying themselves, giving warnings, etc., they started beating him. And they beat him with pads. The gentleman passed away. The family was notified after they had already beaten him to death, and the gentleman was unconscious. There's videos of it happening. That should not have happened under AB 392 because of the protections for individuals who have mental health issues, because an officer is not supposed to be using deadly force against someone who's not posing any threat to anyone. There's videos of this. It's difficult to watch, but these are the kinds of examples where AB 392, if applied correctly and if followed, would have ended in a different situation.
A follow-up question to that, would that situation have constituted objectively reasonable force under the old standard, like the Graham test?
Even under the old test, I believe that I actually think that even in that example, the objectively reasonable should not have been reasonable, because it was quite unreasonable for a gentleman who's asleep without threatening anyone or without even posing any risk to the officer should be beaten to death. But AB 392 does create additional protections for individuals and to ensure that there's lower likelihood that any deadly force will be applied. And the other key change under AB 392, and thank you for those questions, is to consider the officer's conduct leading up to the use of the deadly force. So, for example, what role the officer had in escalating or creating alternative situations where the deadly force is necessary. This looks at conduct leading up to the use of the deadly force and can include, for example, any information that was provided to the officer through a dispatcher when they received the call, or any information once they arrived on scene. Next slide. How's the pace? Okay, great, thank you. So to just highlight some of the key changes is that the previous case, Graham, no longer sets the legal standard for deadly force here in California. And there is a stricter standard now in place where deadly force can only be used when necessary. It's higher than an objectively reasonable standard and requires alternatives that are, if those alternatives are safe and feasible. It also requires that the officer's conduct be considered leading up to the use of the deadly force. And it places limits on fleeing individuals, and it also no longer justifies any deadly force used against someone where the only threat is to themselves. This is meant to significantly increase and improve, in my opinion, interactions between police officers and any individuals who need wellness checks or who have some sort of disability, who for years people have been scared to call police officers because they don't know how those interactions will play out. AB 392 is meant to improve those situations so that there's better and clearer guidance provided to police officers, and so that people who have such sorts of disabilities can feel safer and can contact law enforcement officers. And AB 392 also defines deadly force, imminent threat, and we'll be covering those definitions shortly. And also speak more about this.
I have a question. I get that textually AB 392 sets a higher standard for police officers, but do you have any data about how courts are interpreting AB 392? Like, I'm an attorney, but I'm not a criminal defense attorney. And so what I'm curious about is, are there, in the case law, are police officers being held to have, like, used force unreasonably at a higher rate than before, for example? Like, do you have any data about how courts are actually interpreting the text?
I don't have any data on that specific point. What I have seen, even though we don't have data on it, is that even in some of the charging documents and declaration memos that are being issued by district attorney's offices, the standards that are being used and how an officer's conduct is being evaluated, sometimes they're still not fully in compliance with AB 392. And so as a result of that, you're receiving memos where where the conclusion is that the officer was reasonable in their use of force, but that's no longer the standard. So I think there's still a significant need for district attorney's offices to be using and applying the correct standard, because otherwise we're going to continue to see conclusions where officers kind of violated AB 392 but are held to have not done so, or are found to not have done so, simply because they're not being analyzed under the correct standard.
To the extent of your knowledge, do you know if the Orange County District Attorney's Office is in compliance with the AB 392?
I do not have any immediate answer to that. I will say that at least a few months ago, when we were attempting to look into OC declination memos, and I didn't check today, but I think we can look that up easily. We had trouble finding any memos online because the website was broken. So it's hard for us to analyze if we don't actually have memos that we can review. So I can't give you an answer as of today, but happy to look it up. I'm sure someone here can pull that up and see if we have memos. Because the memos help you assess. And there's slides later to point to how you can review for those memos. They help you assess whether the right standard to be used in the analysis.
If your organization at some point does have a memo analysis, it would be great.
Thank you.
I have another question. How does AB 392 fit into the constitutional framework? And I guess what I'm thinking is like, someone gets arrested and an officer uses force against them and they want to bring a Fourth Amendment challenge for like unreasonable use of force or something like that. Like, how would this law factor into a court's analysis of that?
We're actually covering that in the other considerations, but it pertains within the context of jury instructions. And so after AB 392 was passed, another bill, AB 230, was also passed, implemented later that year in April. And as of then, it required the changing of jury instructions so that the jury instructions can be in compliance with an analysis under AB 392. So there are several sections under those instructions that have now changed to ensure that when people are reviewing such cases, they're using the standards that are set forth by this law.
Thank you. I just want to make sure there isn't confusion. AB 392 is used in California state court negligence causes of action, or can be used against the police officer criminally. It's not used to change the Fourth Amendment analysis or framework, correct?
That's correct, and thank you for that clarification. Yes, I'm still focusing on within the California standards. The Fourth Amendment remains, the analysis on the Fourth Amendment remains the same and continues to be grounds objectively reasonable, but for California, there's a higher standard that is to be used. And so it makes it, it raises the level on what.
It helps. So a police officer could violate AB 392, but still be within the constitutional framework. Like they could not have violated the Fourth Amendment, even though they violated AB 392. Is that correct?
That's correct, because an officer under the Supreme Court case Graham could have used force in a way that was objectively reasonable, which would be acceptable in all those states that are still applying Graham. Here in California, that's no longer the law, and so in California, you would need to comply with AB 392, and so there are situations where you can be out of compliance with current law in California, but in compliance with Graham. Some definitions before we proceed. Deadly force under AB 392 means any use of force that creates a substantial risk of causing death or serious bodily injury, including but not limited to the discharge of a firearm. The key word I want to highlight there is substantial. It's not any risk of causing death, it's a substantial risk of causing death. And so whether someone's force was deadly in nature is going to hinder on what they were using and whether that object was going to create a substantial risk of causing death or seriously bodily injured. And it, again, doesn't have to be limited to a firearm. It could be any other object that could substantially result in someone dying or being injured. So AB 392 also defines imminent threat of death or serious bodily injury. And so for the threat to be imminent, the person has to have the present ability, opportunity, and apparent intent to immediately cause death or serious bodily injury either to the police officer or to someone else. As you can see, these definitions are very specific and have several elements to them. So when there's an investigation into an officer's use of force, it's really important that whomever is investigating and issuing charging documents is actually answering each of these prompts, because otherwise it's difficult to assess whether there was indeed an imminent threat of death or serious bodily injury. So for an imminent threat, it has to be apparent that the person can actually cause an imminent threat of death or serious bodily injury. So the present ability, the opportunity, and the apparent intent. So it has to be apparent to the officer that they have the intent to cause death or serious bodily injury. It does not include merely a fear of future harm, no matter how great the fear. So if all the officer says is that they were scared of harm, that in itself is not enough. It's important to really dig into the situation, understand the facts and what happened, to be able to assess whether there was an imminent threat or whether it was mere harm, including future harm, which is not enough for use of force, use of deadly force. And again, this is all considered under totality of the circumstances, so all facts known to the peace officer at the time, including the conduct of the officer and the subject, and along the person involved leading up to the use of deadly force. So now under AB 392, we're looking at both conduct of the officer and conduct of the individual leading up to the use of force. It can include as well any information being provided to the officer in a dispatch call, because that's also information that would influence their conduct at the time. Thank you. For reasonable officer, there is part of AB 392 that still involves a reasonable standard, and I think that's the part that can sometimes be confusing and that has led to contradictory reports saying AB 392 didn't change anything, because AB 392 drastically altered when an officer can use deadly force. The part that does still include reasonable is that it's all within the perspective of an objectively reasonable officer. So the decision by a peace officer to use force shall be evaluated from the perspective of a reasonable officer in the same situation. This accounts for the fact that peace officers do receive training on how to respond to situations, and so it's not a reasonable person standard, it's the reasonable officer based on what an officer is expected to know about how to engage with individuals, use de-escalate situations, etc. Peace officers must use other available resources and techniques instead of deadly force if reasonably safe and feasible to an objectively reasonable officer. Again, this relates to the alternative requirement. And reasonable expectations related to evaluation and use of alternative resources and techniques, whether force was necessary, may be different for a trained officer than for a lay person. So it's not whether, maybe I'm not the best example, but say someone walking down the street, it's not there of whether they thought it was objectively reasonable, but rather whether an officer, someone with their training, with their experience, thought it was objectively reasonable. And the reasonable officer evaluation is not 20/20 hindsight, but it's based on analyzing whether the officer's views were reasonable at the time of the incident, based on the facts and the conduct leading up to the use of the deadly force.
Question. So when you mention objectively reasonable officer, right? And I'm curious as to if you can elaborate a little bit more on what that exactly means, because we are aware that the militarization of law enforcement exists. Somebody who's trained in law enforcement is trained to do the very much things that this bill is trying to prevent. So if somebody is objectively reasonable due to their training, how is that objective?
That's a great question, and that is something that unfortunately is, I think, just part of a bigger conversation about what are excessive police policies are and when force is used, what the purpose of law enforcement is, etc. So in some ways, AB 392 does continue to operate within the perspective of what a reasonable officer would be based on what reasonable officers have been operating in for some time. AB 230, which is the other bill that I mentioned earlier, that was passed, that was implemented months after AB 392, did provide for training and guidance that was to be applied for officers to ensure that AB 392 did have an effect. There is not a slide on AB 230, but I'm happy to read just the general categories of like the kinds of trainings that were supposed to be provided to police officers to change the way that they consider use of force, and to try to create some impact on the training itself to alter the kind of training that has been provided in the past.
And is that training on, what, 230, 232 only for deputy use of force or for use of force?
It's for use of force.
Yeah.
And give me a second. Government Code 7286.
Just as a follow-up, if the policies are unconstitutional, that is a separate cause of action under Monell, as opposed to demonstrating that the officer was somehow negligent, correct?
Yes.
And then, so if an officer's going to trial on a negligence cause of action and the standard is set forth in AB 392, isn't it relevant that other case law has established what a reasonable officer would do in that particular situation? So for example, if an officer uses deadly force and it's very similar to another case where a court has held that reasonable force was unnecessary or necessary, would that be a consideration into that officer's actions at the time?
It would be for the purpose of assessing whether something was objectively reasonable. And so, for instance, if a court before AB 392 concluded that some conduct by an officer, the way they engaged was objectively reasonable, then that could be used now, opposed to AB 392, to assess whether the conduct was objectively reasonable. But what's important now isn't so much as whether the conduct itself was reasonable, but rather whether the deadly force was necessary based on the other circumstances that we're about to cover. And so the way to think about the objectively reasonable standard now under AB 392 is within the context of how the officer's perspective is evaluated, but not their actions themselves. So their actions are still subject to the necessary standard, and it differs based on the kind of situation we're in. You do consider whether the officer was reasonable, but it's still, was it reasonable for them to believe that this use of deadly force was necessary because the other conditions were met? You're welcome. So the list for AB 230 is a little long, but it does require law enforcement agencies to adopt or maintain a standard use of force policy that includes required elements that are accessible to the public. Some of the policies that need to be included and that are required by AB 230, sorry, not AB 230, SB 230, or a requirement that officers utilize de-escalation techniques, crisis intervention tactics, and other alternatives to force when feasible. A requirement that an officer may only use a level of force that they reasonably believe is proportional to the seriousness of the suspected offense or the reasonably perceived level of actual or threatened resistance. Requirements, there's reporting requirements that they report potential excessive force to a superior officer. Requirements of clear and specific guidelines regarding situations where officers may or may not draw a firearm or point a firearm at a person. Procedures for disclosing public records, And then requirements that officers consider their surroundings and potential risks to bystanders to the extent reasonable under the circumstances before discharging a firearm. And the list goes on. It's a pretty lengthy list, and I'm happy to share the reasons with you.
Yeah, thank you for that. And I have a quick question about resistance. I'm sure we all are aware of what happened yesterday at UC Irvine. I'm a PhD student on campus. I was there when everything happened. And I'm curious if you can explain resistance a little bit more. And if this is the list you just mentioned, I recall is for any use of force, right? Which could be pointing a gun, hitting people with a baton. Would that qualify as that?
In terms of resistance?
In terms of use of force.
So, use of force, the pointing a gun, well, the using a gun on someone, that would qualify. I do want to be careful with any analysis for like institutions, because in the educational setting, the analysis is a little bit different in terms of what force can be applied. And so, this.
Does it matter that Savannah PD was there? I guess I'm trying to get an understanding of whether the rules apply on campus based on the guidelines that are based on UCIPD, or they apply still to Savannah PD.
The rules apply to Savannah PD, but the analysis for what force and how situations occur within institutional settings, so UCI, UCLA protests, USC, etc., that does involve a different level of analysis based on from the First Amendment context of what's permissible and what force can be used against protesters.
Thank you for
The
that.
temporal scope, just a clear comment on that. So the point in time that we're looking at under AB 392 is the conduct of the officer leading up to the use of the deadly force. And there's case law suggesting that courts consider, previous case law suggesting that courts consider only the moment of shooting is no longer applicable. So you have to look at all the conduct leading up to the use of the deadly force, not just at that point in time where a gun was shot. Next slide. And then other considerations that we've been discussing under AB 392 is using deadly force against a subject based on the danger that that person poses to themselves is no longer grounds for justification. And the Penal Code 835, which is where AB 392 is spelled out, says that officers need not retreat. It clarifies that retreat does not mean tactical repositioning or other de-escalation tactics. So maybe like 20, 30 minutes ago, we had the prior legal authority for police force, for use of force by the police. This is what that legal authority looks like now, post AB 392. The constitutional law, the standards under Graham, that's in some ways the baseline that's applicable in all states. That remains federal law. And it's still evaluated from a perspective of a reasonable officer based on societal circumstances. But what has changed now is that in California, there is that stricter standard based on AB 392. It's the necessary standard. So now the force no longer needs to be objectively reasonable. Rather, it has to be necessary to defend against an imminent threat. And the imminent threat is what we discussed earlier. Opportunity, apparent intent, it means that there's a threat of death or serious bodily injury to someone else or to the officer, not to themselves, only to someone else or to an officer, the officers including someone else. And the totality of the circumstances now includes conduct leading up to the use of a deadly force, still evaluated from the perspective of a reasonable officer, but only if that officer thought that that force was necessary. Now we're going to look at some examples of how AB 392 is applied based on the two circumstances under the statute. So in the instance where an officer used, there was deadly force used, there's a couple of questions. was the use of force necessary for either of the following reasons? Because those two reasons are the only permissible reasons now where deadly force can be used or can be justified under the law. And that is, again, either you're in an imminent threat scenario or you're in a fleeing felon scenario. In both of those scenarios, the law still asks that you evaluate whether there were safe and available alternatives that the officer could have used. And there's also an evaluation that's based on all the facts that are known to the officers leading up to the use of force. So in the imminent threat scenario, so this again is where you're dealing with someone who's not fleeing, right? If you're ever dealing with someone who's not fleeing, then you're always going to be in this scenario, the imminent threat. And in this scenario, the key question becomes, does the person pose an imminent threat of death or serious bodily injury to the officer or someone else? If the answer is yes, then you can, well, use of force can be justified, but it still depends on the other questions. Was deadly force necessary to defend against the threat? If the answer is no, then any deadly force that was used in that scenario is not justified under AB 392 because it was not necessary to defend the individual, to defend someone else. And even if there was a threat to someone else, the officer still needs to consider available techniques and resources whenever they're safe and feasible. So if there's no other safe and feasible available technique, then it's important that any investigations or charging documents identify that and spell that out and actually look into whether there were alternatives available to the officer. And if there were not, then it's important that they note that in the investigation. And you still assess whether the use of force was necessary in the defense of human life based on all facts known to the officer. This goes to an earlier question about whether the force was necessary. Under AB 392, the legislature intended that peace officers use deadly force only when necessary in the defense of human life. In determining whether that force is necessary, officers shall evaluate, and then they are to be evaluated on whether the situation in light of the particular circumstance of each case, and shall use other available resources and techniques if reasonably safe and feasible to an objectively reasonable officer. So even if they deem that force is necessary, they're still required to assess other techniques available to them. And it's only in the instance where there is no other available technique or any other resources that they can use that they did determine that the force is indeed necessary to defend against human life that an officer can use that. But short of that, there is no deadly force that's justified under AB 392. And this just goes a little bit deeper into when force is deemed necessary. And so it's based on a common definition. So was it required by the officer? Was it unavoidable? When you're looking at whether there are other available resources and techniques available, you're looking into whether there was an opportunity to de-escalate, whether there was tactical repositioning that could be used. Could the officer delay, wait, could time help? Could the officer call other resources? Could they call another officer or call a mental health team? Is there someone that can assist and available? Again, if safe and feasible, but these are other alternatives, right? Could the officer have used any non-lethal or less lethal force?
Do these factors come from the statute or are they like derived from case law?
These are not coming from statute, but it's rather based on general available techniques that are sometimes provided in trainings and materials for officers.
Have courts fleshed out what necessary means, like through challenges that have been brought under AB 392?
There haven't been too many cases under AB 392. The one more recent case is gente organizada, which is actually a lawsuit that we litigated, but in that lawsuit, it was focusing on the training that was provided to the officers and how in those circumstances, the training wasn't in compliance with AB 392, and there were actual intentional attempts to provide the earlier training and training under the reasonable objective standard. So that doesn't necessarily answer this question, but it's one of the recent cases under AB 392 on whether it's been in compliance, and that's gente organizada. And then in terms of analyzing the officer's conduct leading up to the use of deadly force, the question is, did the officer's conduct provoke or cause the shooting? Or was there anything else that they could have done to avoid that happening? And when you're looking at the officer's conduct, you're also looking at the individual's conduct, right? And any interactions between the two. Next. We talked a little bit earlier about imminent threat of death. Here, this is just spelling out what each of those circumstances are. So, for example, present opportunity and ability. This is by no means an exhaustive list of what you can consider, but it gives you some examples. So you're looking at the distance between the individual and the officer, right? If an individual is, say, several feet away, can they actually have an opportunity and ability to cause harm to you or to someone else if they're that far away? Are there any physical obstacles in between that would prevent them from being able to harm someone else? Is it happening in the moment or is it in the near future, right? Because remember that a mere risk or fear of harm in the future is not enough. You need to actually believe that there is indeed an imminent threat of death or serious bodily injury, but if all there is a fear that there might be future harm, that is not sufficient for deadly force to be justified.
I have a question. 5 guys approaching a small female officer, and she fears for the near future about her safety. Would that be considered? She should not consider the near future of her safety in that case.
Why would the female officer be feared for her safety, and just based on what you just
the guys are coming straight at her, walking towards her, maybe saying things to her in a threatening manner. I'm having a hard time because all I hear is definitions, but I kind of want to hear like actual. The previous training that we went through, there was it was followed up by a lot of scenarios, and it really helped kind of put all this together. But when I hear definitions, like scenarios like that pop up to me a lot where, well, what if it was just one female officer against 5 guys and they're approaching her in a threatening manner? Or obvious, but then it's 5 officers and it's just one guy approaching them in a threatening manner. I feel like both situations are kind of different.
I am obviously not a police officer, nor do I have any training in like how to respond to those kinds of scenarios, right? So I would actually love some input from the gentlemen in the room who are. So for example, in those circumstances, right, if you are standing, and I'm proposing the same scenario you just presented, if you're standing in a room and you see 5 individuals approaching you, screaming at you, I don't know, using foul language, is there any training provided for ways to respond to that, either through de-escalation or some other kind of tactical response?
In a courtroom type setting, I would consider this like an incomplete hypothetical. There's a lot of things I want to know. Given especially 835 Echo 3, where we talk about the time of circumstances, well, what's the call for service? Was she alone because she didn't wait for a follow, which kind of goes back into her pre-use of force, pre-shooting conduct? Or was it a situation where maybe something else happened elsewhere, a quick pursuit happened, the car was thought to be empty, and somehow there's now 5-on-1 in an alley in a high crime? There's so many different understandings of what exactly took place that it'd be kind of incomplete. Now, would the pure numbers justify a shooting? Not necessarily. But I can't say that it wouldn't justify the shooting. We probably have to go into understanding 835, kind of like the question where you talked about Nevada, interesting case, Nevada be, strictly be Nevada County. That would be a constitutionally permissible use of force, but at the same time, under 835, that probably would not have been good, which I can talk to you about after the fact, I'm getting off topic. But we would now talk about like grant factors to get to that necessary aspect of it, where grant, yes, is subjectively reasonable, but can I use those grant factors to justify the necessary aspect of it? Potentially, right? Number of officers versus number of suspects, that is one of those grant factors. Size, if the guy's got cauliflower ear, that could be something the officers could also, if they've got tap out MMA shirts, if they've got some kind of team that they compete for on an MMA setting, that's gonna all be factors that go into it. So it's gonna be a whole totality of circumstances that we have to get through before we can actually get into just the 5-on-1. The numerics are gonna be a factor, but it's not gonna be the entire factor. There's gonna be a lot more things I'm gonna have to know before I can determine, yeah, we're good to go or no, we're not.
Thank you for sharing that, because, I can just weigh in and, I'm gonna see two hands up. Based on that alone, right, under EB 392, there's still a lot of information that you need to assess, right? Because there's questions of, well, where were the individuals at the time, right? If they are, for instance, if they're coming, if an individual's approaching me, but they're still quite far, and if they're not carrying any weapons, or I'm not seeing like any attempt for them to do something else, then it may not be. There may not be justifiable use of me pulling out a firearm and discharging the firearm, right? So there's like many questions, but what you just pointed out, the example of 5 individuals versus 1 approaching you, that is considered in the analysis, because you're looking at what happened leading up to whenever force was used. And so you're assessing who was present, where were they at, how many individuals.
In other words, it's just not black and white. There's just so many things to consider. It's what I'm trying to.
It's a very fact-specific analysis, and so this, I think you're right in that this can be difficult to follow only looking at the law itself and the language, because at the end of the day, this is what I'm working on is and discussing here is just the various factors that one is to look at when assessing a specific situation, but we're not discussing specific situations because those can vary. I mean, they can vary significantly, right, from what you just presented to many other situations out in the open.
Yeah, I was just gonna say that this was an issue last time with the training, is that I understand like it's helpful to have hypotheticals and stuff like that to really put things into context, but you know, these tests they're fact specific, totality of the circumstances tests. Like one fact could change, you know, an analysis and make it different than, you know, a case where a court found that AB 392 was previously violated, for example. And you know, I think the best way to approach these things is just to look at examples of where courts have found AB 392 is violated, where they didn't, and then you can make your own connections as to whether a situation that we're presented with as an oversight commission is more similar to a violation of AB 392 or more similar to a situation where AB 392 wasn't violated. So I just want to say, like, it's difficult. These frameworks are very difficult to apply.
They are. We do have some slides later that provide examples of the analysis and what is an appropriate analysis under AB 392 and what falls short of the analysis. So when we get to it, we can look at those examples. But these are very fact specific, and so right now what we're focusing on is the factors that one is to be looking at and what one can consider. But at the end of the day, there are many facts that one needs to assess to determine whether the use of force was justified under AB 392 or whether it was in violation. You had a question?
Yeah, it's more of a comment because the situation that Chair Vega mentioned, you know, the thought that came to my mind is immediately what was the officer's conduct related to that.
What was the first comment?
Yeah, what was the officer's conduct? Because situations do not happen out of nowhere. They just don't happen out of thin air. There's context and it's a lot of fact finding. I think that's why previous commission meetings, and I know that's something we'll be scheduled later on, Assistant City Attorney Martinez regarding looking at previous cases that we had had previous incidents that we had had at the city with Santana Police Department, where some of these changes may apply now, where, looking back at those type of scenarios, things should have been handled different according to new state laws. And I believe we do have several incidents previously that we can look at if we can have that conversation in the future. But I just wanted to have that comment.
Yes, thank you for raising that. The other factors that we haven't discussed yet are the apparent intent and need to be instantly confronted, or whether it's a mere fear of future harm. So in apparent intent, for instance, are they brandishing any weapons? Were there any verbal threats, which is the example you provided earlier? Who are those threats to? Is there any background information, right, from a call or from prior knowledge based on any prior experiences with those individuals or past situation, etc. That can be used to assess whether there was a due apparent intent. And then with regards to whether the use of force needed to be applied then and what the risk of harm is, could the officer, for example, have waited? Could they have used other resources or techniques? Were there any de-escalation techniques to create time and distance? In the example provided earlier, right, could I have gone to my patrol car? Could I have called other officers in the vicinity? Like, are there any other methods that I can employ to de-escalate the situation to avoid using a firearm or any other deadly force? Next slide. So earlier we were focusing on the imminent threat scenario. There's one other scenario where deadly force, where AB 392 does authorize deadly force, which is in the scenario of a suspected fleeing felon. And again, I've already talked earlier about the felony component and not any public offense. And in those scenarios, you're looking into whether that person is fleeing for a felony that was involving death or serious bodily injury. So it can't be any felony outside if it doesn't involve death or serious bodily injury. And if that person who's fleeing would cause death or serious bodily injury unless they're apprehended immediately. So for example, even in a scenario where an individual or an officer receives a call for someone who has committed a felony that did lead to death or result in serious bodily injury, if all that person is doing is fleeing, but there is no imminent threat to the officer, no reason for the officer to believe that that person would cause death to the officer or someone else, or any serious bodily injury, that still does not allow for the use of deadly force. You need both of those factors to be met. And when those factors are met, there's still a requirement for the officer to employ additional tactics. For example, they should be warning the individual that the deadly force may be used, or they should attempt to identify themselves before they're using any deadly force. And the officer needs to reasonably believe that the deadly force was necessary to apprehend. Because if the deadly force was not necessary to apprehend, and you could have used some other tactic to apprehend the person, then that's what's required of AB 392.
For the warning, that's the standard that talks about if feasible, correct?
That is, let me check. The alternative techniques is what the standard that's if safe and feasible.
I thought the warning was
The warning, safe and feasible as well. And I did include the text in the earlier slides. But that's just for reference later. Next slide.
A quick question. And I hate to do the what is, but I mean, it's the only way to get a kind of like a handle on this. The felon is fleeing a robbery. Their firearm was seen on them. They did not use a firearm, so they do have the potential of deadly force on them to use against an officer. You see where I'm going with it? So the officer his life could be in imminent danger if the person turns and shoots, correct?
I'm sorry, I'm just gonna have you repeat the scenario because I can't.
Oh, I'm sorry. A robbery has occurred, a felony robbery, whatever you want to call it. The firearm was seen on the person. They flee the scene as the officer arrives. The fleeing suspect could turn and fire and possibly kill the officer. The officer knows that this person has a gun because the person that they robbed or whatever says he has a gun.
And how do they know that they have a gun?
Because the person saw it, it was in their waistband, right?
Okay.
When they held them up, the police arrived, this person takes off. So, and again, I hate doing the what ifs, but I mean, that seems what this ends up being.
Right. And I asked the how do you know question because what happens if the suspect, knowing that they're being chased, for instance, discarded the gun and like left it on the sidewalk somewhere, right? So having been informed that someone is carrying a gun at the moment of the call on its own isn't enough to, it's used to assess whether they were reasonably believe that someone could use force later, but if you're not seeing the gun on them, then that's also considered into whether the deadly force was justifiable at that moment, right? Because the situation just presented is different if you can see it, but if you don't see it, then you don't know. And if they do have a gun, for instance, but it appears that their hands are up or they're not attempting to use it, then I think at that point, there's still no justifiable use.
No, I understand. I fully appreciate that. Again, they're fleeing the scene. I understand you just can't shoot somebody. I get that. I mean, I think we're all reasonable enough to understand that. It's just that, to me, it's the officer is at a great risk knowing that that person has a firearm. You don't know if they're going to turn and shoot. So to me, it seems it's kind of a, you know, I would not want to be in the officer's position because you don't want to have that moment of doubt. Right? Because that person can turn and shoot and the scenario isn't so good then. So that I just, you know, I know it's a lot of what ifs, but, and that's what seems to be problematic for everyone here is it's not cut and dry. It's all fact-based scenarios at the time. So, and I appreciate that's what you're trying to present here. And you know, I understand it's difficult. I appreciate it. Thank you.
Well, and I do agree with you that, it's a difficult circumstance, right? Fortunately for you and me, neither one of us is in those scenarios. And so, I wouldn't have the same training that these gentlemen have, right? Or I presume that I don't have the same type of training, where I think whether someone is carrying a gun might mean something different to me than it means to someone who's a law enforcement officer who on a regular basis carries a gun and is used to carrying a gun and knows how to use a gun, knows when a gun can actually be discharged, etc. So there's many factors that go into play, whereas me as a regular person, I would, it's a different analysis. And this is, again, why AB 392 focuses on the perspective of a reasonable officer and not a reasonable person like us who, we might be more scared of a gun being pulled than an officer.
No, and I appreciate that. I think that's an important point. It's a reasonable officer because again, like you say, as a civilian or citizen, you got a different perspective. And we're all looking at these what if scenarios, but I haven't lived it. I don't think anybody else here has either. So I think that's important that is a reasonable officer.
It's a tall task. I mean, I don't have to say it, but I do think AB 392 and part of the purpose was to, and maybe the SB 230 after was to try to create clear and set more guidance for when deadly force is to be employed to account for the factors that can be considered in these various what if scenarios.
So I know that most folks, I myself learn from examples as well, and it's really difficult to give examples, but I was wondering if you're familiar with the Brandon Lopez case here in Santa Ana, and if that is
not, I've heard some information, but I'm not as familiar as others on this room.
Okay, I was just wondering if that can serve as an example of applying AB 372, but if you're not familiar, then I guess we would give an example. And I also wanted to, it's a comment and a question at the same time. My understanding of the bill, right, and the policy is that because we know, right, that there's biases in the system and because there's biases, rationales and ideologies, these are put in place because if we think of what we fear, 5 individuals coming towards someone, that fear can become from a biases, and this is somewhat of a checkpoint to ensure that we're actually going through protocol and real threat, as opposed to these scenarios that the fear could be very real, but it doesn't mean that it has an actual imminent threat to you. And I think that's the point of the bill, right? And something we should all be mindful that is exactly the intent, and why we shouldn't just have scenarios because we all have different biases.
And that's an important one to just think about, that AB 392 itself does not address biases, right? And I think that is very well one shortfall of the bill, but it is intended to provide clear guidance for whether something is perceived as an imminent threat, for instance, and whether an officer would reasonably believe that someone is going to cause imminent risks to someone else, which are factors that are objective and that an officer should be able to tell, and that shouldn't, in an ideal world, shouldn't account for any biases or any other experiences that someone may have had. But there's more to be done in reform.
I totally appreciate Commissioner Carpenter's frustration with, I think that's something that we all have struggled here for over the last couple of months with the trainings, but just as a comment, and I appreciate kind of like the contextualizing cases because they're not black and white. I constantly refer to this case because this is the case that really impacted the way that I saw policing in the city, where we had a young man, his name was Edgar Vargas. He had mental health issues. He, was brutalized by police. But in that case specifically, the early reports that came out was that he attempted to reach to the officer's gun, and that's why excessive use of force was used on him. But then we wouldn't have found out that actually the police officer lied on the reports if it wasn't because the neighbor's camera was recording that incident. And so, as a matter of fact, those officers, 2 officers, were taken to federal court right here in Santana Boulevard. They were prosecuted. So a lot of the context matters, and the fact finding matters on these cases. But I think what we should be in the way that I'm approaching this as a commissioner, in the way that the AB 392 provides us as a tool to really fully assess the full context of the situation, not just what an officer felt. And that's important for us to really think about AB 392 as a tool for fully assessing the scenario in its totality.
Right, and AB 392 is very specific to the use of force itself at that moment, right? So that's what we're focusing on. But there are other bills that are also protected in circumstances like the one you just presented. So SB 2, for instance, right, does allow for decertification whenever there's serious misconduct by police officers, and one of those grounds of misconduct is any dishonesty, including in the information provided during the police reports or in any obstruction of access to information or dishonesty during the investigation. And there are, through the peace officer standards and trainings, you can submit complaints whenever there is dishonesty or any other form of serious misconduct, and post then investigates those circumstances, and based on their findings, those officers can be decertified, right? So there are other avenues available for when situations like that arise. This, for now, we've been focusing on the use of force.
I just have a comment. I want to echo what Commissioner Perea said about using AB 392 as a tool. I think it's very helpful in helping to assess whether a police officer's use of force was, reasonable or justified. But I do also think we need to be cautious about viewing AB 392 as, providing absolute clarity about whether somebody should be held accountable or not. Because while AB 392 does provide more context than the Graham test, it articulates things more clearly. There are still a lot of things that are pretty vague in the statute that require reasonable minds can disagree on. So, for example, did an officer reasonably believe that deadly force was necessary? What does that mean? You know what I mean? So I just think that we need to be careful about viewing AB 392 as, you know, providing absolute guidance about when a police officer should be held accountable.
Thank you for that. What is important about AB 392 is that it does call out when something is necessary, right? So even if even if it's still being assessed from the perspective of a reachable officer, the key inquiry was whether the use of the force was necessary at that time, and whether it was necessary depends on the analysis of either scenario. Were you dealing with someone who was fleeing, or were you dealing with an imminent threat scenario? If you're in either scenario, then there is no justification for use of deadly force.
Yes, I understand that, but I think imminent threat is also, I mean, what does that mean? You know, what does it mean for a person to cause serious injury unless immediately apprehended? That's the only point I'm making, is that I think it's a step in the right direction, but I think we could all agree that it's impossible to spell out every situation in which an officer, in which we could determine whether an officer should be held accountable. So necessarily it has to have some flexibility in there, and I think that's what the statute does. So that's the only point I was making, is that it provides guidance, and it's a step in the right direction, but we can't view it or use it as like an absolute answer to whether, you know, a police officer that's been accused of misconduct should be held accountable, because there's some vagueness in there.
It's a framework essentially, right, for assessing whether something was lawful or unlawful under AB 392, but it does by no means spell out all the examples where this could play out, because I think frankly that seems really difficult to actually visualize all those scenarios. And even if you were to look at common scenarios, right, even those can change significantly one case to another. So it's only providing you the factors to assess and helping you understand like what an imminent threat would be, whether it was apparent intent, whether they had an opportunity to do so. It provides enough factors so that people can assess whether the deadly force was justified, but it by no means provides for all scenarios, which I realize can be difficult. Can we move on to the next slide? So with regards to what happens after deadly force is used, there are, based on our AB 392, district attorneys now need to apply this heightened necessary analysis to uses of deadly force, which is different from any analysis of non-deadly force. And then there is a need for district attorneys to be reviewing whether there was safe and feasible availability and use of alternatives, including de-escalation tactics and tactical repositioning. Those are all important and necessary to consider when determining whether someone used deadly force lawfully. There also needs to consider whether there was any non-compliance. Any officer's fear of danger on its own is not sufficient to justify the use of deadly force if it's not meeting the necessary requirements of AB 392. And then the conduct of the officer leading up to the deadly force, again, will be considered as part of the totality of circumstances. And the officer's use of force is going to be analyzed under the necessary standard. There's no longer a separate standard that was in place before under California Penal Code Section 196, which was in one of the earlier slides. That is now been replaced by Section 835A, which sets for the AB 392 standard, the necessary standard. Next slide. So when conducting investigations and issuing any memos looking into use of deadly force, it's important to, one, obviously conduct a very thorough investigation just because of the number of factors that need to be considered. Ensure that those facts are being presented in a neutral manner. This is also aimed to eliminate any potential risk of biases, for instance. Where possible, to use pictures, because pictures will help an officer assess distance, what an individual is doing, how they were positioned, etc., right? And to include non-law enforcement witnesses. This also accounts for a scenario that one of you mentioned earlier, right, where it was civilians who had videos depicting a completely different scenario than what the law enforcement had articulated. So where to the extent possible, all investigations should try to present facts in a neutral way and to take the account of law enforcement officers and non-law enforcement officers, essentially any witnesses that were on scene and can help an officer or the person investigating determine whether how the deadly force was used and whether it's lawful or not lawful. And then the analysis does need to include all the elements. This goes back to the earlier point, whereas we've seen several memos that are looking into whether an officer did was justified in the use of force, and some of those memos are just falling short of actually assessing all elements that are necessary. For each element, it's recommended that they state the standard accurately, that they set forth all the facts that are relevant to the analysis, and it's important even to include the absence of some of those facts, right? So for instance, in the alternative resources requirement, if there were no alternative resources, then it's important for the memo to include that and to say it in lay terms. Otherwise, there remains a question about whether there were alternative resources that could have been used, and the memo wouldn't be answering that. And it's important to state the conclusion in terms of the legal standard. Next slide. I'm actually going to move to the next one, please. Maybe one more. I wonder, it's not showing up correctly. Oh, there it is. Can I trouble you to keep scrolling? Okay, there. Thank you. I hope you can see it in your printouts, but essentially what this is looking at is a conclusion in an investigation that was analyzing the situation applying AB 392. And there are sections here that are highlighted in green and then other sections that are highlighted in red. For example, there in green, you notice language saying that Hamilton, the officer, reasonably believed to be faced an imminent threat of death or serious bodily injury. That's articulating the correct standard under AB 392. It is important to also include all the facts for why that officer believed that there was an imminent threat of death or serious bodily injury and why it was reasonable for them to do so. You'll notice that there's other sections there where the way it's being analyzed, it's misaccurately representing the law because it either mixes the analysis of two factors together, and in other instances, it doesn't clearly state the necessary standard or articulate a conclusion of the analysis. There is some good language in there, for example, where it analyzes any alternatives to retreat to consider whether it was necessary for them to use deadly force. And this example also says for facts that are relevant to assess whether someone was reasonable in their belief that there was an imminent threat of death or serious bodily injury. I think the other slides are similar in providing you examples of what is what is an analysis that complies with the AB 392 requirements and what is language that doesn't comport with the statute. Next slide. We can keep scrolling. Well, actually, we can pause there. So this, I think, is clearer on just showing you exactly where the analysis fell short. So in the first sentence, you see Riley's actions at the time of the shooting were reasonable. The standard there, this gets confusing with the reasonable because it's not that the standard was what, the standard isn't whether the shooting was reasonable, it's whether it was necessary, but it's based on a reasonable officer. But the question still remains whether it was necessary. So the analysis indicating that the actions were reasonable can misstate the actual standard that's to be applied under AB 392. And the last sentence in that paragraph, Riley had reason to believe that the suspect posed an imminent threat of serious bodily injury or death to himself or the public. That's the factual discussion is actually leading to that conclusion that, that is consistent with the AB 392 standard. The only language there that's still inaccurate is the reason to believe, because it's not reason to believe, it's a reasonable belief. And I think generally that might look fairly common, but it's important to just be using the language of the AB 392. And in the next paragraph, you see a discussion on the alternatives when to assess whether deadly force was actually necessary. So there, the investigation indicates